Hi, everybody. Please continue to eat your lunch. I know dessert just came out, so we'll talk above your clanging of forks. Don't worry. I'm Morgan. I'm the president here at the club. I'm really pleased to have you all here today with our very special guest, Judge Henry Litton. He is a repeat visitor at the FCC, and we're always very pleased to have him come and give us his insights, talk about his books. And today, of course, we have plenty to talk about with his latest book. Before we get started, of course, I want to remind you all that this is a small sampling of the types of talks that we offer here at the club. If you're not a member, please ask any of our staff about an application. We'd be very happy to have you. We have screenings. We also have wonderful drinks down at the bar. So please do let us know if you're interested in joining us more permanently. And of course, you don't have to be a journalist to join either, so extra bonus. So turning to our guest today, I think he needs very little introduction, but of course, Henry was a former Court of Appeals judge. He's a third-generation Hong Konger. He was called to the English bar in 1959, appointed to the Court of Appeals in 1992, and the Court of Final Appeal in 1997 before retiring in 2014. And since then, he has kept very busy writing books that you see here, available for purchase today. And the proceeds of the sales do go to charity. So extra bonus if you are purchasing a copy. For the books, we have Law in a Hot Air Balloon from 2023, Reflections on Democracies, Autocracies, and Other Fallacies from 2022, The Dance of Folly 2021, Can Freedom and Liberal Values Thrive If Common Law Crumbles from 2019, and Is the Hong Kong Judiciary Sleepwalking to 2047? His latest book is being launched today and will be available in Hong Kong bookstores. It is called The Blind Leading the Blind. So we're going to hear a little bit about that. The cover is I'll just show it to you guys too. Cover looks great. So I know a lot of you here from the legal community have a lot of questions and are eager to get those in as well. So I'll start us with some questions, but I'm going to be sure to save ample time for you guys to ask questions too. So think about those as we're going through things. As soon as we get ready for that, just put your hands up. We've got staff coming around with microphones, so that way we can be sure to hear you clearly when you have your questions. All right, without further ado, let's talk about your book. Tell us a little bit about the premise for The Blind Leading the Blind.
Well, to start with, let me thank you, the president, your committee, for your generosity in allowing me to speak in this marvelous antique remnant of architecture from someone who is himself an antique remnant from the past. Though I do sit here actually with, you can say, a sigh in my heart and a tear in my eyes as I contemplate in my mind's eye the slow motion train wreck of a legal system which once was characterized by humility, brevity, and clarity, and is now clouded, shrouded by hubris, complexity, and maturity. Let's just take a look at the bigger picture. In 1967, there was rioting in Hong Kong. Now, did Britain send an aircraft carrier task force to deal with the situation, as recently other leaders of the free world did in other places? Or was Hong Kong left to deal with the system of the crisis on its own, relying on a system legal system which was effective, robust, and forceful. And with those limited resources concentrated in Hong Kong, the situation was stabilized, the emergency was dealt with, and Hong Kong then continued on the road to prosperity. Fast forward to the year 2019. There was rioting in the streets, we all know that. And at that time, the judiciary became overwhelmed and paralyzed. Of course, the legislative system just ceased to function, totally dysfunctional. Agitators then were playing games with the courts. The basic law itself was turned into a weapon of mass destruction. Legislators made mock of the swearing-in ceremony. And how did the judges react? They, I regret to say, nodded their scholarly heads and allowed all that to happen, and then they thanked counsel for it. Hong Kong was on the verge of total collapse until Beijing stepped in with the national security law to save the policy of one country, two systems. Humility, brevity, clarity. Those are the foundation stones of the rule of law under the common law system. Clarity, brevity, self-evident. I don't need to explain that. Now, humility, what do I mean by that? To me, it is the cornerstone of the system. It brings everything down to earth. It mandates focus. It equates the work of a judge with the commonality of mankind. A judge, though he sits high on a bench, is not operating in a legal sphere detached from society. He functions as part of a larger governing system with appropriate awareness of time and space, like anyone else who carries heavy responsibilities. Situational awareness is the key, and it is a matter of mindset, not of law. As the Bible says, for everything there is a season and a time to every purpose under heaven. Now, what is the purpose of a judge? He is there to deal with the rights and liabilities of parties. He's not there to deal with social problems, family values. His mindset, if it were focused on humility, is concentrated. Or, if you like, 萬物必有個機緣，來時不先也不後. Or as the Bible tells us, when John the Baptist was asked, "Are you the Messiah?" His answer was, "No, there comes one after me, the latchet of whose shoes I'm not worthy to unloose." There comes one after me, the latchet of whose shoes I'm not worthy to unloose. Just a few words. Humility, brevity, clarity. Now, that is the mindset I suggest, which should invade or be contained within the breast of everyone who discharges judicial duties. It comes from a healthy mindset, a mind uncluttered by self-doubt, by anxiety for approval by others, and the need to demonstrate scholarship, assiduity to job, learning, etc. Focus on the job at hand. And that largely was the system that I came back to when I was admitted as a very young barrister to the Hong Kong bar in March 1960. Now, the common law system. This common law system, entrenched now, of course, in Article 8 of the Basic Law, is one built up from the grassroots, from the interaction of people inside in society, step by step, brick by brick, as judgments from the higher courts create precedents. It is not a system, something imposed from the top. The work of thinkers, scholars, academics. It is the product of interaction at the grassroots. It is therefore pragmatic and practical and focused on remedies. The trial judge, now let's talk about him. As Chairman Deng Xiaoping, the architect, I remind you, of the Hong Kong system itself, once said, quotes, "I care not whether the cat be black or white, so long as it catches mice." Now, that mindset is the guiding principle of governance of Hong Kong under the policy of one country, two systems. It is pragmatism. Whatever governs best is best. That is how Hong Kong prospered. It was, I think, Thomas Carlyle who says, "For forms of government that fools contest, whatever governs best is best." Now, that sort of pragmatism, I think, has been totally lost from the practice of law, both on the part of the bench and of the bar. As to trials in court, the first function of the judge is to identify the real issues. That is to say, the parties' issues, not those concocted by lawyers. Now, since the civil justice reforms in 2008, I think Ching Hong would remember them, I hope, and Order 1A was added to the rules of the High Court, judges have a statutory duty to actively manage cases. No longer could that be left to the lawyers. Amongst the duties imposed on judges was, quotes, I quote from Order 1A, quotes, "to promote a sense of reasonable proportion and procedural economy." Reasonable proportion, procedural economy, unquotes. And to this end, judges are required to identify the issues at an early stage and to decide promptly, quotes, which issues need full investigation and trial, unquotes, and to dispose of the rest summarily. And lawyers have a statutory duty to assist the court in achieving these objectives, Order 1A, Rule 3. I regret to say that, in essence, Order 1A has been completely disregarded, both by bench and bar alike. Now, this blueprint was devised for civil trials, but the principle is valid for all causes, be they criminal prosecutions or the vexed jurisdiction of judicial review. Now, with such discipline imposed on the profession, how is it possible that the court process generates judgments that run to multiple pages, tens, hundreds? And in the Fanning Golf Club case, for example, 225 pages, and the latest reasons for verdict in the Jimmy Lai trial, 855 pages with 1,812 paragraphs. Now, how does one in practical terms deal with such monsters? It is beyond human, at least my intelligence, to absorb comprehensively such mountains of material. Now, expressed in English, how do you translate all this stuff into Chinese? And yet, 90% of the population of Hong Kong do their reading in Chinese. So what is the law to them, to the common man on the street? As the former Chief Justice Ma, at the last ceremonial opening of the legal year, told the audience, he said that common law was based on precedents, the output of judges, and how important it was that people should understand the law. He said, and I quote, "The wider community must also deepen its understanding of our common law system in order to make it work," said the Chief Justice, unquote, "in order to make it work." Now, how can any system work when it's buried in an avalanche of words that no one can understand? I think the former Chief Justice's statement would have carried more weight if he had quoted from the Old Testament, quotes, "A fool's voice is heard in the multitude of words." Ecclesiastes chapter 5, verse 3. Descent into obscurity. I trace this loosening of discipline back to the early 2000s, when the Basic Law became part of the legal landscape. It provided a new playground for some lawyers who prided themselves as advocates for human rights. And to me, perhaps the most notorious of the cases is the Citizens Radio case back in 2008. Now, the radio spectrum, as you know, is strictly controlled because it's a limited resource. It is used by aviation, the police, fire services, and so on. And it comes under the Telecommunication Ordinance, which makes it an offense for anyone to maintain or operate any means of telecommunication without a license granted by the Chief Executive in Council. Nothing simpler. The defendants, in open defiance of the law, operated what they called a citizens radio on FM frequency without license. When brought before a magistrate on a charge under the ordinance, they had no possible defense. Their guilt was beyond doubt. But they were acquitted by the magistrate on the ground that the system of control under the ordinance was, quote, unconstitutional. The power of control given to the Chief Executive in Council under the ordinance, the magistrate said, had infringed the right to freedom of expression guaranteed under the Basic Law. Now, this was just pure nonsense. What's more, the magistrate himself had acted unconstitutionally because his only mandate was to deal with the matters set out in the charge sheet. Nothing more. Humility escaped into thin air in that scenario. Naturally, the government took the matter on appeal to a single judge as required under the magistrate's ordinance. Instead of quashing the verdict and sending the matter back to the magistracy for proper determination, the judge ducked his responsibilities and sent it upstairs to the Court of Appeal. The Court of Appeal, in turn, treated the matter with knitted brow, with discussion of law beyond the ordinary understanding of man. Page after page after page of it, European jurisprudence, of course, got piled onto the smorgasbord. Ultimately, of course, the magistrate's verdict was quashed, but not before encouragement was given to lawyers who saw an opportunity to use the Basic Law as a weapon of mass destruction. Judicial review, perhaps the most vexed abuse of process in let's talk about it. Now, about 10 years ago, I got a law student to do a check on the number of Forms 86, which is the form by which you make an application to a judge for leave, for permission to start proceedings for judicial review. You have to ask the gatekeeper, can I go through? And by that stage, 50 odd Forms 86 had been lodged by a man called Kwok Chuk Gin, who prided himself as the Phad Lut Phokhat Wong, judicial review king. And doubtless he boasted the triumph that he'd scored amongst his friends in the tea house he frequents, I suppose, for dragging the chief executive yet once more before the court, represented by senior counsel, junior counsel, paid for by legal aid. Piling obscurity on complexity. I think it reached probably new heights in the face mask case, which was decided at first instance at the climax of the insurgency in 2019. By about October of that year, the police was under such strain, was ready to collapse, and it was itself the target of attack. It took 3 or perhaps 4 officers to arrest one assailant at the risk of their own lives. And when brought to the police station, their identity could not be ascertained. They, of course, against the law, carried no ID cards. Street cameras were useless because they were masked. So the prohibition of face covering regulations was brought in by the chief executive, a group of well-known agitators headed by Leung Kwok Hong, no less, Long Hair Leung, and a whole tribe of the usual suspects, immediately resorted to judicial review, supported by legal aid, to challenge the constitutionality of first the regulations, but also the underlying statute, the ordinance, which gave power to the chief executive to pass regulations, the emergency regulations ordinance, which has been in the statute book since 1922. Now, one look at that Form 86 lodged by Leung Kwok Hong and his friends would have convinced any thinking person that they were mischief-making. The first question would have been, now wait a minute, the law requires some interest on your part before you go to the court. What is your interest in this matter? Oh, you want to go out rioting, but in disguise. Now, I mean, the matter was as simple as that. And what's more, the Form 86 that they lodged to challenge the regulations and the ordinance said contravene 9 articles of the basic law. Now, how was the judge to deal with that? I mean, 9 articles scrambled together like, Chao Fan or... Now, instead of looking at the thing as a piece of absurdity, which it was, what happened? 2 judges were appointed to hear the case, turning it into yet another cause célèbre. And it resulted in a 100-page judgment in which the court grandly declared that the regulations and the ordinance itself were unconstitutional under the new order brought about by the Basic Law. And of course, European jurisprudence was piled onto the table as part of the smorgasbord again, and figured prominently in the reasoning of that 100-page judgment. The judgment triggered such an unprecedented reaction from the Legislative Affairs Commission, which said that it was, quotes, a blatant challenge to the authority of the Standing Committee of the National People's Congress and to the power vested in the Chief Executive by law to govern, unquote, which it damn well was. It took 2 appeals and a cumulative 318 pages of text, more than 200,000 words, for this anomaly to be eradicated. The first instance judgment was quashed, for there was nothing arguable in it. Now, for effective exercise of the rule of law, the application for leave to start proceedings should have been dismissed with 6 words. There's nothing arguable, application dismissed, full stop. Now, how are we doing for time?
Probably want to move on to questions fairly soon. But
Well,
you want to keep going a little bit?
well, I don't know whether this is, making your digestion now troublesome, because I've got actually even more absurdities. Do you want to hear it?
We do.
Okay, all right.
I think we do want to hear about your book, too.
Well, I mean, look, I'm sorry to say, my book is just repetition ad nauseam of anomalies of the kind that I've just highlighted. Perhaps some of them not to such heights of absurdity, but that label you can probably attach to every one of the cases I've analyzed in this book. Now, it would certainly spoil your digestion if you even try to read it. So for your good health, maybe I should counsel you not to buy it.
Or buy it now and save it for later.
Now, look, I tell you, I've got such a... I tell you what. I told the former Chief Justice, when the fire in my belly subsides, is the time for me to retire from the Court of Final Appeal. And stupidly, I retired before the fire in my belly had subsided. And therefore, it's now been turned to stuff of this kind. Now, look, this is serious, to me anyway. The bridge, the big bridge, Hong Kong, Macau, Zhuhai Bridge, one of the biggest civil engineering project in the whole world. I think at one time it engaged half of the world's largest dredgers, for example. And I'm told that the steel wire, which is then spliced into cables, which then suspends sections of the bridge where it's, there's spans of it over the water, had to be spliced in Hong Kong in order to make these cables. And the wire, of course, has to be imported into Hong Kong to be spliced into cables. And the wire imported would have circumnavigated the globe. Now, this was how big that project was, okay? Now, the Hong Kong had 3 portions in Hong Kong N, and 2 of them were complex and costly and came under the regime of the Environmental Impact Assessment Ordinance, an ordinance for the authorities to consider the impact on the environment of a project of this size. And of course, it needed the coordination of the 3 governments, Macau, Zhuhai, Hong Kong. And the project started in 2003. And these works, by their very nature, necessarily damaged the environment. And the proponent of the scheme, the Highways Department, was required under law to propose measures to mitigate the impact on the environment. Now, by October 2009, the Director of Environmental Protection was satisfied that the necessary measures were in place. So on the 5th of November 2009, she issued the permit to commence work for those sections in Hong Kong. In early 2010, a Madame Zhu Yiwa, living in a small flat in Tung Chung, got leave, once again, from a High Court judge to start proceedings for judicial review against the director, seeking orders to quash the permits to commence work. Now, this by its very nature would have had the widest possible impact for the entire project. For something of this size and complexity, any delay would be catastrophic. Now, surprisingly, the matter did not come on for hearing until February of the following year. And Mr. Justice Falk, who heard the matter, did not explain why. In April 2011, he handed down his judgment, 62 pages, 189 paragraphs. It is clear from page 1 that as far as mitigating the environmental impact of the proposed works was concerned, the Highways Department had satisfied all the requirements. So why was the matter in court? The judge tells us this in paragraph 27. Now listen carefully. Quotes, "The applicant's complaint," that's Madame Zhu Yiwa living in a flat in Tung Chung, "the applicant's complaint related to the adequacy of the air quality assessment of the operational phases of the projects," unquote. Air quality assessment of the operational phases of the project, says the judge. What on earth does that mean? Well, if you read on for 2 more pages from the judgment, you realize with a sense of shock that Madame Zhu was supposedly concerned about air quality in Tongzhong, not whilst construction work was going on the ground near her flat, but way, way into the future, to the year 2031, no less, when the bridge would be, quotes unquote, operational. That means carrying motorized traffic, which bridges do. Now, here, really, one reels with disbelief. Now, the meteorological office sometimes predicts tomorrow's weather inaccurately. And here was a judge concerned and talking about air quality over Dongzhong 20 years into the future. When the bridge is built, the bulldozers retire, the ribbon is cut, and the VIPs take their first ride from Hong Kong to Zhuhai, and perhaps in an open-top car. The project itself is finished, over, complete, no more. And if that open-top car in which they were riding on the way to Zhuhai emitted black smoke to the annoyance of Madame Zhu, it was not the concern of the director, and he was not to blame. The environmental impact assessment for the civil engineering project had no further relevance in the case. There's really nothing more to say, except that there was a damn sight more to say. For if the hapless reader valiantly plows on, he'll reach, for instance, paragraph 80 of the judgment, where the judge says, quote, "In my view, it is highly material for the director and the public to know, for instance, what level of NO2, one of the main air pollutants resulting from a road project, are predicted for the future," unquote. Level of air pollutants predicted for the future, said the judge. Well, now the Romans built the Romans built bridges which lasted 2,000 years is the director and her successors for generations to come to be responsible for air quality over Tung Chung until the bridge crumbles. It's just not possible to hold unreason and common sense in the same breath. Now take paragraph 86 as an example, quotes Mr. Shi, who is counsel for the director. Mr. Shi submitted that when one looks at what is required in terms of the air quality impact assessment, now wait for it, in SB, that means study brief, a guideline for air quality assessment, the impact assessment in SB 3.4.1.4, it is clear that the reference to background air quality levels in clause 3.4.1.4 brackets 1 small c was a reference to the background in the historical sense, unquotes. Now, all this was in the context of predicted air quality over Tung Chung in the year 2031. And there are pages and pages and pages of this stuff. I think in the Middle Ages, the scholars actually took time to count the number of angels that could dance on the tip of a pin. And that seems to me to be what was happening in that court at that time. Mr. Shi interprets 3.4. Blah, 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 blah in one way, and Mr. Dykes interpreted in another way. Now, it's impossible to explain how the judge, after 186 paragraphs, came to the conclusion that the director's permit to commence work had to be quashed, which he did. Now, relief in judicial proceedings, judicial review proceedings, is always discretionary, in the sense that it is a jurisdiction to be exercised in the interests of good governance. And yet there's not one word in the judgment suggesting that the judge had given the least thought to the wider public interest, how the project might be affected, how costs might be involved if the director's decision to permit work to commence was quashed. Now, for a decision of such magnitude in the real world, the decision maker would think long and hard before reaching a conclusion, but not in the dream world of microscopic analysis, computer modeling, and counsel's arguments. Now, as I opened the talk, I said, I speak to you with a sigh in my heart and a tear in my eye. Since I published in 2018 the book of essays entitled Is the Hong Kong Judiciary Sleepwalking to 2047? 4 books of the same genre have appeared, and the 5th has just come out today, and this is it. But the dysfunction in the judicial process is now so manifest, and I believe that the court lists are so jammed, that it really wonders whether the system itself is fit for purpose. Or perhaps to put it another way, has Mr. Deng Xiaoping's cat gorged on junk food for 20 years, grown so fat that it can only dream of chasing mice? Thank you.
Thank you so much, Henry. That was wonderful, some great examples in there, and I know you guys have some questions. I see people jotting down some notes. I did as well. I will put my questions aside and let you guys jump in there. So just put your hand up in the air if you have a question. We are scheduled to end at 2 o'clock, but I think we can go a little bit over today if everyone has a bit of time. If you need to get out, feel free to, but we'll try to get to as many questions as we can. So just put your hand in the air if you would like a microphone. Or not. Okay. As I say, or if okay, great. We've got a question right in the front.
Thank you. In 2022, there was a discussion amongst leading jurists in Hong Kong about the necessity of continuing to have overseas non-permanent members of the CFA. I wonder if you could comment on your views about that.
Well, they have certainly made a great contribution, I think, to the judicial process in Hong Kong, because, I mean, the Hong Kong jurisdiction is very small. I mean, a population of 7 million odd people doesn't really generate a big range of issues to be resolved in court. So obviously, highly respected judges, experienced judges from overseas, with a much wider experience, can come to help us to reach judgment in the highest court, is in principle highly welcomed. On top of that, some of the judges, well, now serving on the bench, are highly distinguished jurists with worldwide reputation. And in particular, I think Lord Hoffman, who actually, as it happened, was a contemporary of mine at Oxford. And already at Oxford, he had a high reputation for brilliance of mind. And I'm so glad to see that he's still on the non-permanent judges list from overseas. Well, I mean, the short answer to your question is yes, I'm in favor of overseas judges serving on the Court of Final Appeal.
A lot of what you talked about today was this breakdown of pragmatism and discipline in our judiciary system here in Hong Kong. Is there something that you think has triggered that, and is this unique to Hong Kong?
Unique to Hong Kong? By no means. Absolutely not. The same syndrome has unquestionably also seeped into some of the judiciaries in Australia. I mean, when I say judiciaries, of course, there's the state level, and then eventually there's a high court. And this is a failure to actually look at the real issues and to compromise, argue at the edges. I mean, let me just give you an example. When you say rape, what does it invoke in your mind? I assume a forcible, violent assault on womanhood of really a heinous degree. Now, can there be rape and maybe rape? That you judge rape when you make the accusation in a criminal court, it's beyond a reasonable doubt. But in a civil court, well, on the balance of probability, she consented and maybe not consent, but on a scale of 49, 51, well, maybe she did not consent, and therefore she was raped. and therefore the person accused of rape in a civil court becomes a rapist, whether he's been convicted of rape in a criminal court or accused and found liable in a civil case of rape in a civil process. I mean, that sort of distinction to me is just, again, common sense. Okay, now this is just an example of what has fairly recently been happening in this is actually Victoria again, jurisprudence. So no, I mean, the answer is no. We are not unique in this regard. This gentleman here.
I think I'm loud enough for people
Okay.
to hear. What about, for example, England? Has that? I mean, I very much appreciate some of the old English judges, such as the late Master of the Rolls,
Lord Denning.
Lord Denning, you know, and phrases like the man on the Clapham omnibus. I mean, they are just classics. How badly have the English courts been affected?
Well, let me answer your question in two parts. Number one, may I shake your hand and acknowledge your insight and clear thinking in realizing what a superb judge Lord Denning, Master of the Rolls, was. In fact, I started a project actually in the Hong Kong University Faculty of Law, which I called, and present a prize annually, which I called the Bluebell Prize. And it's taken from a judgment of Lord Denning, where he started the judgment by saying, it happened on 19th April 1964, full stop. It was Bluebell time in Kent, full stop. It painted the picture of a woman with her 8-year-old daughter in springtime picking bluebells in the woods. Their family car was parked in a lay-by, and the husband was making tea from the back of the car when a Jaguar, totally out of control, came screeching around the corner, smashed into the back of the van, killed the husband, injured 2 of the kids, and she was happily picking bluebells with an 8-year-old across the road. The question is, what sort of damages should be awarded to her years after the trauma had subsided? At that time, the idea of post-traumatic disorder syndrome had not actually entered into the medical vocabulary. But the question was she suffering from nervous shock of such proportion as to require substantial compensation? And Lord Denning was basically sustaining an award of substantial damages in the Court of Appeal. And he just looked at it, you know, those 3 words, humility, clarity, brevity. Humility in the sense that he looked at it from the human point of view. Never mind about, you know, the very expert doctors who argue one way, argue the other way. He cut through the chase, look at it from a human point of view, and upheld in law the award of substantial damages. Now that's the first part of my answer. The second part, I would delegate my responsibility to Grenfell Cross, who knows far more about the situation in English jurisprudence now than I do. Sorry, Grenfell.
for the judiciary in England to tell us more about the current situation of the judiciary in England in terms of, you know, the how they would deal with such a case.
I've really landed you in it.
I have to talk it back to you, Henry, because I'm not familiar with the situation in England just now. Maybe Chen is.
Well, we can debate this afterwards as well, but I think we've got a question back here. And then after that over here. Yes.
So what interests me is that in my lifetime, I think we've gone from the rule of law to the rule of lawyers. And I think that's really what you're saying, is that judges saw themselves as being part of the people. They might have even gone on omnibus. I don't think any judge in England today even knows what an omnibus is, let alone go on one. And I think we've got to a point where the law has become detached from the average person in the street. I think there's always been a danger of that in Hong Kong because of the Cantonese English thing. And I think that's made worse in Hong Kong, potentially because of that.
Yeah.
But I do think this is a worldwide phenomenon. If I look at the courts in the UK, I look at the courts in Australia, it seems to me that the lawyers are no longer coming from a class that understands ordinary people and is coming from some sort of elite, really, that has a totally different view of what ordinary people need and want.
Yeah.
And therefore, the law's becoming detached from society as a result of that. So the general trend to me, just to reflect that again, is that we've gone from what I grew up as being proud of the rule of law to now being very suspicious of the rule of lawyers. I don't know whether you would agree with that.
I agree with every word you've said. I could not have answered better, so that is my answer, sir.
Question over here.
Thank you. If I could bring it back to Hong Kong, perhaps be a little controversial. In the last few days, the Beijing Liaison Office has made some statements that make it very clear that the role of the judiciary, amongst its roles, is to support the executive. And it's very much clearly now subservient to the executive-led administration that we have here. So is it now appropriate maybe that to your three, brevity, clarity, humility, we need a fourth, which is obedience?
I mean, the law doesn't change with the complexion, ideology, social values of an executive administration. So there are situations which, of course, the law needs to support the executive in law enforcement. But in law, in a criminal law, for example, in the criminal jurisdiction, under the national security law, the basic tenets of the common law are wholly intact. That the prosecution has the task of establishing facts relevant to the charge beyond a reasonable doubt. Now that remains totally intact, and I don't understand that statement to actually deviate from that fundamental principle. But if it does, then it's, of course, very disturbing.
Do we have one more question? Yes, right here.
Thank you, Judge Litton, for coming back to the FCC. I think the message of brevity, clarity, and humility is something we can all take into our lives, let alone jurisprudence. You mentioned the 850-something judgment and verdict in the Jimmy Lai case. You also mentioned before national security law. Forgive me, I may be one of the few people in the room who's not a lawyer. so I will be expressing this in somewhat layman's terms. To my understanding, the national security law is not retroactive, was not designed to be retroactive. In the Jimmy Lai case, the 3 judges ruled that they would accept evidence from the prosecution of Mr. Lai's behavior before the national security law was implemented, as it might pertain to his character or intentions after the law came in. To my understanding, this was somewhat unconventional or unusual. I'm wondering if you could please pass comment on that.
Well, don't forget, actually, there were 3 charges. 2 under the national security law, but 1 under the crimes ordinance. And one of the problems, I think, with the reasons for a verdict is not to have distinguished between the elements of the charge in count 1, which is a conspiracy to commit sedition, directed only against the Hong Kong government, as far as I can see, or at least such evidence there was directed against the Hong Kong government. And evidence focused upon the charges brought under Article 29(4) of the National Security Law, which of course is on a very much narrow spectrum of time, as you say, quite rightly, only from the 1st of July 2020 to the time when Lai was arrested. So that mass of stuff that you were talking about is not clear to which of the charges it was directed. And that's one of the problems, I think.
I'll end us with one last question for you. Should common law remain in Hong Kong after 2047?
Well, the whole focus of this multitude of words is directed really to one aim, to hope or to ensure that the common law system does endure and is the governing system in Hong Kong after 2047, which hopefully is a legacy that our generation leaves to the next. And as I actually tell you, if you read the back of don't read the contents, there's too many pages.
You're going to ruin your publisher over here.
What I said was, this is the underlying question. Is the one country, 2 systems a promise of 5 decades? 50 年不變, okay? Or is it reality for all time? That's why I've been slaving away with a multitude of words for quite a few years now. That's the whole purpose, as far as I'm concerned. It gives no pleasure, really, to expose some of the really gross failing of process, which I expose in the multitude of books and in the multitude of words. A fool's voice is heard in the multitude of words, and in this regard, please treat me as a fool.
Well, thank you, Henry. I think we've all enjoyed that very much.
Thank you.
Great. We have a small FCC gift as a thank you for coming as well.
Oh, wow. Well, look at that.
So you can take that back as your carry-on, a little gift on the inside too.
Oh, I see. Well, not to be opened before Christmas. Thank you so much.
No problem.
Thank you for your kindness in